Good afternoon, everyone. So we'll be starting now. By way of introduction, my name is Chinoya Naji. I'm the coordinator of this webinar. So we'll just delve right into it. So our topic for today is understanding software development cycle and licensing, technical and legal impurities. So the idea is just that at the end of this, we'll be aware of business, technical and legal considerations that we should bother ourselves with when we think of software development and its entire scheme. So I'll just introduce our panelists. So we have Ugochukwu Kike, an associate at Punuka Attorney and Solicitors. And then we have Nana Eze, who is an engineering manager at Adela. This webinar is brought to you by FintechBloom and Pronamic. FintechBloom is essentially an information dissemination center for anything relating to fintech. So we do things such as directories, trainings, and the whole ball game. Now, Pronamic Hub is basically a business development enterprise as well as capacity development. We'll have one of the partners speak to us shortly at the end. So I'll just hand over to the panelists now. I hope that we enjoy it and it's beneficial. Thank you.
Okay, so good afternoon, everyone. I'll just jump right straight into it. Shinoya has already introduced me, and my name is Nana. I've been in the software space for about 7 years now. So I would just like to share my experiences across this time. And though this conversation will largely be about things relating to software, it's strongly geared towards the legal context. So first of all, what does software development entail? So I know a lot of you, you guys have seen software developers and you think they're all nerds and geeks, and the screen that you have right here is what you imagine software development to be, a bunch of gibberish that you really would not be able to understand. And words like Java, PHP, Python, and weird names have been thrown around a lot during your time when you hear about software development or software programming. But today, this is not one of those things. This is not us trying to come confuse you, but to just show light as to what software development is. It takes beyond just the programmers. There are a lot of considerations towards building a software. While we are going to focus on those considerations, we'll also be looking at it from the legalities of it. What things do we need to do that we need to take into consideration what the legal implications are. So if the layman asks me today what a software project is, I wouldn't say it's anything different from the normal projects that we normally have in place. There are three primary constraints that usually hinders or makes or breaks a software project. And that the time, the cost, and the scope of the project. So lots of times when you have a project or you have an idea or you have a concept and you want someone to build a website or a software app for you, you first of all know that this is what you want, and then you engage the software developer. Now, by engaging the software developer, then there has to be an approach towards building this, bearing in mind that you need this ready at a set amount of time, and the source is not unlimited. You can only pay for as much as your pocket can carry. So just bearing all this in mind, that you have to think about the time, the cost, and the scope of the project brings a set of nuances that you have to consider when you then are looking at building this, and also looking at whatever implications legally that this is going to bind. So in terms of the legal implications, I would hand over to Ugochukwu, who is actually just going to throw more light as to what this legalities entail.
Thank you, Nana. So basically, when a developer considers the need to, or when an end user needs to actually develop a software, there's, like you've noted, there's a slight disregard for the need to have certain legal requirements or standards put in place. So the whole idea is to ensure that in a software development life cycle, just as the developer is concerned with building certain core features that would perform the requirement that the end user wants, he has to also consider, or both parties have to also consider the legal implications. So, for instance, I would give a scenario. I would say, if you take a look at the Adobe Reader, you'd notice that you can download an Adobe ebook reader, And when you purchase a book, you are able to use that book on the rental structure, meaning that you can only access that book on the device where you bought it from or the device where the Adobe is installed. Now, as a purchaser, you don't have the capacity to copy that book. You don't have the capacity to use that book or read that book in another device. So Adobe has created a restrictive platform because they want to enjoy certain rights that they have or certain licenses that they have. But then you could have like an enthusiastic software developer who feels the need to ensure that he's able to optimize the Adobe Reader or Adobe application to ensure that customers can have access to read and use the book in other devices. And then he creates, for instance, a software that assesses the Adobe features and grants features of development or features where you can actually read, copy, and use other devices to access the Adobe. Now, Adobe could decide to sue that developer for copyright infringement because the good thing about it is that we need to understand that a software is a computer program. And under the Nigerian Copyright Act, a computer program is also copyrighted, is a copyrighted work, which falls under the literary works, basically. Secondly, we also want to understand the fact that there are other intricacies that come, which is what we'll talk about when we talk about the scope of the software itself that is being provided. If I want to provide a payment service gateway solution, I would need to understand that, yes, my payment service gateway solution is going to help or assist individuals to make seamless payment online. But then I would have to look at the legal implication, which is what license do I need? So I know that if I go to the CBN or any other regulatory body, I would require to have certain features put in. Other features will have to be considered. And in doing this, in putting all this, in ensuring that these concerns are adequately buttressed, you have to ensure that your entire development life cycle puts all these different requirements analysis in place or in structure. Going forward, I would later discuss as to the issues of ownership because I could actually engage a software developer to develop a software for me. And then based on the angle of copyright, the question is who expresses that idea? Because I may have an idea that I want to probably build a product or an enterprise solution that will help HR services. But that's an idea. The person who actually expresses that idea in form of computer programming language and a physical software that we can access would naturally be seen as the owner of the of the copyright or the software. So on some contractual arrangement, you have to identify these. So if you're an end user, a recipient, who wants to engage a provider, a consultant, a software developer, whichever name you want to give it, you would want to ensure that every right that the contractor would enjoy as an owner deemed from the copyright angle is assigned to you. So all these are structures that you have to put in place in a software developmental life cycle, and they come in different places. But I'll let Nana go further to discuss the models for software development life cycle, and then we'll be able to pinpoint how we can arrange or structure the legal audit on this.
Okay, so I know Gochuka has mentioned a lot about the software developmental life cycle, but what does it entail? In layman's term, this is the steps that it takes from building a software from when the concept is first provided down to when the solution is delivered and you have something that the end user can use. So generally, there are two approaches when building a software. One of which is the waterfall model, and another being the agile cycle. Now, the waterfall model has been around for a long time, and this is what has been used, which was used in the early 80s and the late 90s. And what it entailed is that you had about 5 steps whereby the client gives you the requirement. After what you do a design, and then you do the coding and testing and maintenance of this. Now, originally, you can't actually go to the next step without completing one. So for every step, what happens is you have whatever negotiations or conversations with the client, and then there are documents that are signed off after each stage ends. Now, these documents in themselves serve as some check marks, because like I mentioned earlier, you have to make sure that the scope is well defined. You have to also make sure that it's within a time frame based on the plan that is negotiated, and also it meets whatever quality. So the documentation brings about the blueprint, to which if there was any legal lawsuit, you have to use that as a checklist to see if it met whatever contract that was entered into while building the software. Agile takes a whole different approach, and we are going to discuss about it as we go on. So like I mentioned, a classic waterfall approach, like the image shows, is as though water is flowing from one layer to the other. It has to start from a place and go to the next. Without it having one stage totally executed, you can move over to the next. And then the final software is going to reflect the requirements that was scoped out in the beginning. But then there are certain drawbacks to the waterfall. First of all, the client a lot of times would not know what he wants to build in mind. And which means when you are 6 months down on the project, then you begin to realize that, okay, maybe I didn't really think about certain things. And a change in the requirements affects the cost of the solution, and it might even lead to an entire rebuild. So imagine working for 6 months and then a scope change, and everything you did for the past 6 months becomes null and void. But from the software developer's perspective, all he needs to do is just complete the project, whether it makes sense or it doesn't make sense. This was what was given to me. This is what you paid for me. If you want to change this, you either pay more money or we extend the time of it. Another problem with the waterfall approach is it doesn't take into consideration things like technical debt. Technical debt being there are bugs in the solution, which maybe based on oversight wasn't considered during the requirements, or there is some change in the legal infrastructure within the economy, or even the market changes. It doesn't take into consideration that, and even when you build it and you hand over, in terms of maintenance, it's not the purview of the software developer. So when we go on, we'll talk about some of these things and answer some questions as to how you can actually deal with this. Then comes the Agile approach. So the Agile approach is another approach you can take to building your software, whereby instead of waiting for all the 6 months that you follow one step to the other, whereby once you finish one, you can't go back to the previous step. It takes things at an iterative and incremental stage. Now, what does iterative and incremental mean? Most especially when you look at it from a contractual point of view. So imagine having a very large software that you need to build. So rather than deciding everything that needs to be built right from the beginning, what you look at is break that software into smaller bits called increments. At a stage whereby every increment is built, once the first increment is done, that increment goes live based on whatever features that was agreed in that first increment. Then the next increment is built, and then another increment is built up until the end of the software. And this gives room for user feedback and change in requirements to be inculcated during the software development lifecycle. So it emphasizes more of working solutions as against written documentations. So the time whereby you would have spent writing documentation to make sure that you are covered in case of any damages, you spend it more in writing a solution. I'll tell you that during the time that I actively programmed, I've come across like 100-page requirement document that you had to digest even before writing your first line of code. Now, this is one thing because software developers, if it's not code, they really don't want to be bogged with a lot of things. But then again, when you have 100-page, 200-page document that you need to first of all digest to know what exactly the requirement is all about, you can't start a project until you've read everything. It's like reading a textbook. Then if you get to the testing phase, if there's the waterfall approach, there's something called the UAT script, whereby a quality assurance analyst or a tester writes a set of scripts, which can be 10, 20 pages, that you have to check that everything that was built actually meets the standard of requirements that was set out in the scope. But then again, that's another long list of documents. So you discover that in Waterfall approach, you can't actually really do something except all those documents exist and you are checking out everything in that document so that once it's at the end of the project, then you can hand off and move on to other projects. But the incremental approach takes a different angle, and it allows you to collaborate with the stakeholder so that if there's any change, there is flexibility to adhere to that change. And there is something that you can actually see in the middle of the project as against waiting to the end of the project where you see the working solution. So, like I've mentioned in between my my deliberations, Waterfall deals a lot more with a fixed scope, which means once the scope is set and signed off, there isn't much room for change. If there is a change, then the client needs to either pay more or the time of the project needs to be elongated. It's not flexible. But then for Agile, it allows for a lot more flexible scope and then flexible time. Now, this seems very theoretical, but when you look at it from the legalities of it, what does it mean to do all this? And I think Ugochukwu is going to really speak to all these things as to what best fits, what approach best fits whatever idea that you want to really put in place, and how do you cover yourself from any legalities that implies.
Thank you. So Nana has been able to give us a basic understanding of the developmental life cycle for a software, and it's going to be pretty difficult to determine which would actually be more compatible with maybe certain legal impurities or considerations and how to comply with it. On a clear first-hand view, I would say the waterfall approach would be easier because, like he had noted, there are step-by-step requirements. So you fulfill this requirement, you move to the next slide and stuff like that. But before I even delve deeper into that, I think from a legal perspective, we still want to gain an understanding of why are we really doing this. If you check the software development life cycle, whether Waterfall or whether Agile, and if you go back to their different models, for instance, we have the capability, maturity, model integration, which is maybe ISO 15504 and stuff like that. You check it, you find out that there's no core legal audit or standardized legal process, which is supposed to be coordinated at the same time we are developing your software. So for instance, if you are looking at some technical functionality and you're saying, this is the criteria that you want the software to perform. So I want the software to probably have to synchronize with other devices. That is a functionality of the software in terms of technicality. But then you want to look at from the angle, oh, what are the legal angles? And I'm going to just make it a little bit clear on the legal angles. First thing is clear that a software is an intellectual property. So there comes two angles inside it, which is there could be issues of infringement and claims from third parties, one. Secondly, there could also be issues as to how you can exercise your right of ownership. We've dovetailed around that. We've talked about a developer who is acting as an independent contractor. So in that regard, the structure changes because under the Copyright Act, like we've explained, it's the person who expresses the idea in a specific format that will be deemed to have ownership. And copyright, like we know, is the right to copy, the right to use, the right to distribute, the right to license whatever right you enjoy from it, and the right to produce derivative works. And if I am an end user or a purchaser and have engaged you as a developer, which is what we usually have in Nigeria, I would need to clarify this. I would need to ensure, which is another aspect of the developmental life cycle, I would need to ensure that the contract is clearly stated, stating that the developer is assigning all copyright, all the licenses, all his rights, granting everything to me, the end user. So that would make it clear. But most developers don't know this. So naturally, the natural course of situation is that the developer who develops a software for an end user or whoever or recipient naturally enjoys the ownership of it. Now, the dimension or begins to change if the developer is under a work for hire as provided in the Copyright Act. Now, for the work for hire arrangement, you have someone like Nana, who is an engineering manager in Andela, so he's a developer there. But Andela provides a form of a third-party outsourcing, software outsourcing services. So he, as a developer working for Andela, would be considered as an employee of Andela. And so the Copyright Act creates this situation what we call the work for hire. And under the work for hire, anything you do which is particular or related to the functionality of of your employer business will be deemed to be owned by the employer for a specific period of time. So those issues are clear cut. So you notice that maybe in his employment contract, these things are clearly identified and distinguished. So these are part of the beginning basic developmental issues that you want to consider when you want to actually develop a software, either from a developer point of view or an end user point of view. Another angle is infringement claims. Now, when you look at like the Adobe situation we talked about, you would notice that there are risk of you involving other third parties to perform certain system functionality for the software. And in doing that, those third parties may have certain claims on your software. That's one. And on that basis, you also want to clearly, in the development lifecycle, put the criteria, the legal requirement to process or interconnect or interoperate with these third parties. And you have to do it together, a combination of both technical development and legal requirements and legal processes. Now, he talked about scope creeping, which is a very critical or practical situation. Because imagine I'm a developer and you come to me to develop a software for you. You have a basic idea of what you want, which is, oh, I want my software to be able to perform HR services. So this is a descriptive services. But as you begin to delve deeper, the software developer will probably notice that there are certain core features he needs to add. And if you guys have not appreciated the features before you actually gave him or engaged in this contract, there are issues, because I'll come from the angle of, the scope of work which you actually asked me to do has been expanded because maybe we'll have to add some added new features, or because some new regulations are coming into place that we need to comply with. And so these are situations that needs to be analyzed. So in doing this, the practical situation is rather than preparing a software development contract separately and then preparing subsequent contract that will address these new add-on features, you could just do a check-in order. And so what this check-in order will be doing is that it will serve as an addendum to the software development contract that you've executed with the developer. So in the event that the developer sees that certain criteria of functionality has to be introduced to the software, he issues a check-in request. And when it does this, you confirm as the end user if these are modes you want to be added. And if you confirm that it actually is, you give a check-in order. And in the check-in order, you could put a clause to ensure that in your software development agreement, the developer would ensure good faith in negotiating according to the current market standards so that you are not shortchanged. So these are practical ways to reduce some of these challenges. Another angle is to say, because sometimes you want to use the software. So you have the part of the development of describing the specific functionality of the software and part of developing the software based on that criteria. So you could brief the developer to say, oh, this is my general idea. I want to do the scope. I want to bring out the core functionality of this software. And after you do that, that will be for a separate fixed fee. Then after you do that, we'll have another arrangement where I would engage you further to build that software based on the specific functionality that you've itemized and defined. The challenge for the developer would be that in the event that you agree to develop the specific functionality for the software separately from building the software, there's a risk of the end user taking your specification and then giving it to another third party to develop. So those are some of the nuances that you have to correct when you are drafting the contract. And you would also notice that some stakeholders have to be involved. Now, when I mean stakeholders have to be involved, you would find out that there are multiple parties to this whole arrangement. And when it has to do with a system or a structure like an umbrella, the developer may not be concerned with all these situations because you have like the talent managers, you have the development analysts and all those who would consider these implications. Why the developer himself would only focus on core development as the requirements that they have stated. So as a lawyer, you're asking yourself, how do I partake in this whole software development lifecycle? The first thing, first of all, is to ensure that in the development lifecycle, you identified a strategy for managing the risk, which is the legal implication. Because then secondly, when you've identified the strategy, how you want to map it out, the second would now be to now identify the core legal risk. We've talked about the ownership risk, the copyright risk, the infringement risk. There's also the when the product goes into market, there's a risk attached to that, which is maybe data security, data breach, privacy, compliance with certain guidelines and requirements, or even retention. So you want to put that in place. You want to put it as a checklist in your audit review. And you have to do this harmoniously. You can't do this separately. It's not the legal audit or legal processing is not autonomous or separate from the software development life cycle. They are structured together. So at this point, it begins to get clearer for you as a lawyer how you can aid a developer. And for a developer, you begin to see the need why you probably need a lawyer to help you navigate these nuances in the development of software. But I will leave now to probably make some further practical.
So yes, beyond the legalities of it, when a product goes to market, there might be cases whereby because of the marketing strategy, a new requirement comes into place. Say, for example, I'm sure a lot of us have heard about the GDPR requirements, whereby if you are building a solution that will be used within Europe, there are certain standards that you need to put into place. Now, this is something that you might not have thought about while building the solution, but then when this comes into place, this needs to be accounted for. If not, it's not going to be accepted within the European sphere. And even down to when a software is built. I remember last year, the US Senate called Mark Zuckerberg, and then they were drilling him as to the Privacy Act whereby they could use the user's data to do as much as they wanted, which was an infringement on the citizens' rights. Now, in things like this, it's always best practice for an engineer to understand what the law says when it comes to that. And if there's any new requirements that wasn't originally added to the scope, a change request comes into play. And after that change request, once it's built and scoped and costed, it's added as an addendum. That way, it covers himself from anything of that sort. And mind you, I'd always advise in cases like that, that a software developer employs the use of someone who can read in between the lines. That's a lawyer. Because there might be things in that new addendum that might invalidate the original contract. And when you take it to the court of law, it makes it null and void. So it's always best that you actually employ the use of such people. So beyond just writing code and then delivering it and having a working software, thinking about these things, whatever change, whether it be in requirements or in terms of the law. Now, if it's in terms of a functional specification changing, imagine if this doesn't imply that it changes, there's no change in law. But then there might be other impacts that it might have on every other part of the system. So it's always good as well that you do an impact assessment to say, okay, this very change, how is it going to affect every other thing or all the other modules or features in a way that doesn't invalidate all the checklists from the scope that was originally given, most especially if you are using a waterfall approach. For Agile, it's a lot more flexible. You don't have all these things in Agile because it's very iterative. If this was the case, in the next increment, you factor it in and you make that change. But for waterfall approach, you have to take into consideration, because if you make that change and it goes against what was originally stated in the earlier scope, and that doesn't cover whatever impact that's going to have. If the client comes to sue you that you didn't actually deliver the software that he asked for, you can't go back to look at all the documentations, both the requirement document, the system specifications, and the UAT to really pinpoint to say that this is what was asked to build, and this is what the change actually resulted to. The change might result in the entire project changing from the original scope. So from time to time, we also need to take that into consideration. Now, beyond just this question, there are certain other things that you have to do to mitigate any risk post when the software is built. And Uko is going to talk about it. And we would use a case study of a payment system that we all use every day to actually interact in our day-to-day lives. Because sometimes you have to think about, if I was to be dragged to the court of law, what steps have I put in place to indemnify myself so that I'm not the one paying a heavy the heavy cost to whatever stakeholder that takes me to court. So Ugochukwu is going to talk a lot about that mitigation strategy.
Thank you. I can notice that we're almost running out of time. But so what Nana is introducing is the fact that after developing the software, there's a need to perform certain product assurance. And product assurance is a major way of actually mitigating or reducing your risk. So I would structure product assurance or assessment into two aspects. Now the first is to first of all validate the process of the development, which is what we've been talking about already initially, which is the developmental life cycle. So you want to validate the process of development of that particular software. And in doing that, you probably want to look at license compliance. Now, license compliance seems like an abstract here because you need to get the license that's the copyright license, which is different, but the license to use a software, which is different, another contractual arrangement, and the license with respect to certain underlying software or source code that you use. So for instance, if you're using a free open source software, there are underlying licenses that you have to comply with. So, and most developers, most times when they build their own proprietary technology or proprietary software which they sell, they tend to overlook this scenario. And it's very necessary because now, for instance, you might have a free open source code software that you use this documentation on their frameworks or libraries to create your own proprietary feature. That particular free open source code software, I would for short call it FOSS. That particular FOSS would have certain license requirements. So we'll have like the MIT license and things like that. We have some permissible licenses that allows you to copy the entire source code and just put a notification stating that there are no liabilities. There are other ones that give some permissible permission to copy and distribute. Some gives you some restriction that says that insofar as you're copying that particular work and reworking it or modifying it, which is an angle of copyright, remember, at that point, you have to ensure that you probably cannot distribute or sell your end product. So this is a subset of how a lawyer or a risk manager or a business analyst has to review the product assurance or the product quality at the end. So you want to systematically itemize the process of development and validate it. So what is software integrity like? When there's a forking, what's the community like? What are the structures that is put in place? Forking here will probably mean when there's a force reset to create another external feature separate from what that software is doing. So those are considerations. So you want to look at that if you're actually using some different underlying source code licenses. Then after you do that, which is one angle, you now also want to evaluate the product quality and the product functionality. We've been talking about functionality, so I'd like to probably give a broad understanding. So for some people, when you have an idea, you probably have a scope of it, but you are required to ensure, or you're required to ensure, you need to ensure that you have clear-cut technical architecture, that is features that software needs to do. So if you know that you need software to be fast at a particular speed, it has to be clear-cut. You know that you need the software to synchronize, it has to be clear-cut. The best way to do this is not to leave the function specification of this the function specification of the software to say open-ended, where the developer can insert or develop with state. You have to make it clear in your contract so that when there's an issue, so I'll give a common scenario. For instance, imagine you own a factory, for instance, and then you engage a software developer to build a widget tracking software solution to monitor the factory floor. And he gives you software widgets monitoring version 2.20. Then you find out that when you start using the software, it doesn't give you the kind of speed that you need. So it's not generating the report as frequently as you want it to. Worst thing, you probably figure out that the software is not even synchronizing with your factory manager's handheld devices and other devices that it needs to use to ensure interoperability. Those are concerns. If you do not iterate this in the system functionality or the technical architecture of the software, whichever you want to call it, it becomes a challenge in the contract to hold the contractor liable. You get. So the contractor, on the other hand, who is the developer now, needs to also be able to allay the concerns of his client to say, oh, in this agreement, this is what, or this is the criteria that we set for this for this software to provide or this system to provide. We did not agree that the speed will be as high as this. We did not agree that it's going to synchronize with some devices. So if these are clear cut already, it becomes easier. And there are different people that can can prepare this. It's not just a technical function. Yes, you could require your IT expert to be involved in this, but you would also need the people in your department, say the HR, for instance, or the factory manager who understands the core intricacies of the services that you communicate with daily to state, oh, we want this software to have this feature, that feature, that feature. Then you need your lawyer to make it simpler in a simple agreement. So those are situations. Also, it's not closed-ended. Everybody has to be involved in this system specification. And if you notice, there's still the place where, while during the developmental stage, there could be need to expand the system specification, which is what we talk about, the check-in requirement. So if you notice, everything is beginning to flow in that light. So you evaluate the product, and in evaluating the product quality or functionality, you identify what are the core product function, which we've already talked about. You also want to identify whether the product meets certain criteria, like speed and everything I've talked about, or what are the action plans that will be taken in the event that this product does not meet criteria. So if, for instance, it's not fast enough to communicate with your other clients, maybe to generate an invoice, what is the effect? So what are the risks that would occur based on these lapses in the product to meet this criteria? You want to identify this risk. Then you also want to identify how this risk will be mitigated. So when there are multiple actors in the system, which will delve deeper into, you want to identify who would bear these liabilities. How will this risk be mitigated? Also, you want to identify some features that can begin to perform nevertheless, or notwithstanding the lack of software to meet all its initial criteria. So while the developer is building and trying to patch and fix these criteria, you want to ensure that certain core aspect of the product can still be performed or can still be carried out. So all these are part of your risk mitigation protocol. And from an end user part, also you want to identify other end users who have used their developers or the software providers services or software, because you may not be able to provide all the parameters or all the risks that are in place, but someone who has interacted with this software more and more would have an understanding. So you want to also identify with those people, understand the uptime that the software has, and the other intricacies. You also want to look at the security angle. So I'm giving you the process. You want to look at the security angle. What happens in terms of breach? So you probably want to look at from data security. You want to look at from the encryption, third-party evaluation, switch. Where if there's a need to communicate with other third-party providers, you want to identify whose roles. So from an end user perspective, you may have the right to authenticate, so protect the people who are going to have access to that software. From the back end, which is the developer, you may have the obligation to ensure that those data are encrypted. You have the right to ensure that when there's an attack, say a spread denial of service, other stuff, the software has an integrity to continue to function, notwithstanding. So those are clear-cut parameters that you want to identify under your risk assessment. And then you want to do an acceptance testing, which is another core critical aspect that you would need to consider when you're drafting the contract, to ensure that the specific functionality of the software matches upon delivery of the software, and then matches with the expected behavior that you want the software to perform. So you want to benchmark this together in your contract. But we're going to go further to consider the procedures for defining these actors, parties, or parties' liabilities. Currently, the kind of structures we have for lawyers who may not be technically educated is that you do a blanket liability, or something like just clearly monolithic. So it's not, there's no variable. You just say this party will bear, party A will bear liability, a blanket liability, and party B will bear liability, or even probably even limit your liabilities. But this scenario may not be the best scenario in a software functionality when you want to identify actors' liabilities, because the aim at this point is to ensure that when there's an issue, when claims arises, so for instance, the end user who probably engages an e-commerce platform to make purchases, and then he makes his orders, and the e-commerce platform sends the orders he has made. In that process, there are different component parties. So you may have the mobile phone service provider who interacts with the end user, that's using the end user's phone. You would have probably the signature provider who has the app to authenticate the signature of the end user. Then you also may have the smart card where you want to ensure that the PIN that is inputted by the end user is correct and authenticated. So at this point, if the end user claims that, oh, this order that you sent to me was not the correct order that I made, who bears the liabilities? So in doing this, you have to identify, but this comes in different formats, because this would come if it's a direct end user agreement or end user relationship with a direct software developer. It will look like as if the software that's providing that services. So for instance, the e-commerce platform will bear the risk. But no, in beneath all this back end, there are different other component parties or actors who may have liabilities for this deficiency in the software functionality. So the lawyer, while looking at the legal issues, has to look at the business consideration. So you have to do this with the technical guides, right? So to now identify the core technical requirements. So for instance, like I've said, there's a functional behavior that you want your software to have. And you have the component parties that have to make sure that this behavior, expected behavior is performed. So what happens when that document is not the right document, or not the right order that I made? Someone bears the liability. So at the back end, it seems like, oh, maybe the mobile phone operator will bear the liability because he's the one engaging you directly. But at the back end, it may be the owner of the signature app. It may be the smart card processor who will bear the liability, maybe because you authenticated a PIN that was not the right PIN. And there are requirements to look at the technical way of identifying these liabilities amongst the parties, as opposed to just doing a blanket liability agreement. So at the end of the day, the objective is to translate it. So when we've done all this, we're able to now identify everybody's informal liability. So party A, when this occurs, you are going to bear this liability. And party B, when this occurs, you are going to bear this liability. And party C. So this is like an informal arrangement. But the lawyer brings that informal arrangement based on the technical issues and then applies it to the contract. So it's clear cut. So I don't want to go deep into the technical issue, because now on the technical angle, you start looking at things like the tracing properties and the errors to identify, okay, who is at fault here. Because there are sometimes when customers will bring endless claims, and when you look at the back end and look at your log entries and your imputations, you figure out that no, nobody was at fault here, nobody committed any error. You get? So at that point, the customer would be notified and he could pursue whatever he wants to do. But you have your log entries, which shows as record to identify that there was nothing or no liability for any party. Now, I want to make it clear that you need to understand that who bears liability is not a consideration of whom there must be at fault. Sometimes I may bear more liability as a mobile phone operator because I would have more quota in the commission of that product. So it's not based on core functionality. At the end of the day, party B may be the one at fault, but party A may be the one bearing the liability. So you don't need to brainstorm your mind and ensure that, oh, this has to be based on the technicalities of the outflow. So you have to find a way to balance it. And you want to look at the legal context of all this too. In a contract where you limit someone's liability, you need to confirm, should this person's liability be limited in the event that he probably did not perform his own activity, maybe based on the malicious content, maybe based on negligence and stuff like that. You also want to use the log entries when there are disputations in court to identify and say, oh, we have clear-cut evidence to show that. And thankfully, we have electronic evidence that has been admitted right now, because clear-cut evidence show that, oh, these parties were not liable for these situations and stuff like that. But I would allow Nana probably give us a more technical scenario using, considering that most of us are fintech enthusiasts or experts. You probably want to use that scenario because that's what we engage with most, payments particularly.
Okay, so I know Gochuka has said a lot, but to show a bit of appreciation for some of the things that he's talking about, I'll give an example or a case study of one of the things that we use on a day-to-day basis. So imagine a case whereby you want to make a payment and you go make a POS. You go use a POS in a merchant cycle. Now, this is what happens in the back end. It's complicated. One of the many things that I know what most of us have experienced is when we go use an ATM or a POS and then they tell you, or if something happens and you go to the bank and they tell you it's network problem. But what exactly does network problem mean? I've been in a situation whereby I took an Uber trip and for one reason or the other, I was double charged. And then I had to go meet my bank that this happened. Now, in a case whereby such events makes me incur a heavy loss, maybe I was going for some serious contract and something happened out of the blues and I make a heavy loss and I need to sue somebody, who exactly am I going to sue? Because when you look at this framework, there are different parties. You have the card holder, being yourself, the retailers, the acquirers, the payment scheme, and the card issuers. Not to worry, I would explain a lot better what all these things mean. So breaking this down, because this is a whole complicated scheme, you need to realize that all these different value chains heavily make use of software, which means because they use software, someone is liable. Now, this software might not be built by the bank. There are third-party vendors within this vertical. Say, for example, the card holder, you have a card. It has a chip that's programmed inside. So as long as the software, it's always liable to a fault. Then the retailer end, which is the merchant, the acquirers, and all these other places, they use software. And if something really doesn't work, that makes transactions not flow in a seamless way, someone has to bear the cost of that liability. So going further, I'll just typically explain who these actors are. And then while myself and Ugochukwu are having a conversation, then we can now start taking a look at, based on everything he has said, as regarding the liability framework, who bears what. So the card holder being me and you, is the person who goes to make this payment. And my expectation is once I go to make this payment, I have money in my account, I should receive the payment. Then the retailer can be your ShopRite teller machine, where you put your device or your card into and then insert your PIN. Mind you, the PIN that you put might not be, might be handled by third-party vendors. A hardware security model whereby once you authenticate and it goes through all that flow, it then comes back with a message to say that your PIN is correct and so you are approved to do this. Then the merchant bank, who is called the acquirer, then interacts with the payment scheme. The payment scheme that we know in this case is MasterCard and the Visa cards and the likes, which when you go to the bank, they ask you, what card do you want, Visa card or MasterCard? And you now have another party who is the card issuer, which is now your financial bank, the one who gave you that card to actually make use of. So this is a typical example of when all this happens. There are lots of interactions, and these interactions are software interacting with software. Now, in the case that there is a problem and someone has to be sued, it means you have to go into the log files to look at all these things and to know who bears what liability. And is it the fault of in process, or is it a fault that some code really didn't run effectively? And this leaves or throws more light into when someone says that it's a network problem. Okay, whose network? So if I'm sued, if someone sues someone because it's a network problem, who are they in the right place to sue? Who do they get whatever compensation for? So Ugochukwu is going to maybe is going to talk a lot more about this so that we then understand who the different actors are and the level of exposure that they have to things like this.
Thank you, Nana. I can see some questions, and I probably will just make this broader as opposed to limiting it to a POS situation, but it's the same use case, it's the same case study. We've used e-commerce to talk about. Nana has been able to break this down using a payment ATM provider solution or POS solution. So someone is saying, how do lawyers, liabilities are about to rise, and so there are statistical context on how can a lawyer address this in an agreement and stuff like that, which is the whole aim of this section. So yeah, the first thing is, after identifying what the IT system is, that is what the functionality of the software is, you need to identify the components. You know, the components here mean what are the several parties, or what are the several ingredients that will be required for the software or that solution to actually operate. So in this regard, you probably are looking at the server, you're probably looking at the acquiring bank, you're looking at the merchant, you're looking at the payment terminal solution provider, you're looking at the payment gateway, you're probably looking at the issuing bank, and all these different requirements. And then they have the actors. But I'm going to limit our case study because there are different ways to actually to look at this. If I am the lawyer representing the end user, and there's a contract between the end user and the software developer. It's easier. It's pretty basic on that note. You just identify all the core system specification that does not meet your criteria, or that fails to occur during a default, and the software developer or the software provider would bear the risk. Your aim is to identify all of these defaults. But on the back end, because like I said, the end user is probably just engaging the software provider. On the back end, if you are the lawyer who is preparing or getting the agreement between the software developer and other actors, you want to now identify how all these actors are going to interact, how will their features interact with one another to bring out the expected outcome that the end user wants. You get? And it has to be precise and clear cut, because then you now explain everybody's liability when there is a default in the expected outcome. So this is more technical. And you probably want to establish issues or incidents that may occur that would necessitate someone to bear a particular liability. And you should know that we're looking at liability in this context from a software function. We talked about software functionalities and one software to do this, one software to do that, one software to do that. So this liabilities also is being considered as part of a software functionality, which is we expect that based on some mathematical organization where the software does not do this and this and that, it has failed in its system functionality that we've described, and this party would be a liability. This is different from other intellectual property rights or liabilities that will come into play. You get that's a different nuance on its own. That doesn't necessarily come from the operation of the software. That comes from other third-party issues already addressed before. So, but we're talking about the functionality of the software and liabilities on default of the functionality of the software. And so, for the legal context, you probably want to consider having a formal definition of the share of liabilities among the parties. So, we talked about the IT system and the components. We talked about the actors, the different people involved in operating that software. And then, so you also now talk about the informal agreement, where the document is sent to the end user, and that document is not the document that the end user authenticated or signed. Who will bear the liability? Is it the signature app provider? Is it the smart card provider? So it becomes clear cut, and then you can begin to use some mathematical functionality to identify every specific liability that everybody will bear. And to do this now, you do it through what we call a tracing method. And the tracing method would involve an analysis of the logs. So there's a log like we've talked about before. So I want to analyze the log to determine someone's liability after the fact. So after issues have arisen. And under the tracing method, you would have issues like errors on one hand and claims properties. Now, the errors we're talking about here would not be based on the claim of the end user who probably felt that he was debited twice, for instance. The errors here would probably be, when A was supposed to process this document and send to B, he sent B a different document. The errors could be based on network issues and stuff like that. So error is a scenario that you create. So you now itemize the different parties that will be liable for different kind of errors. So you identify parameters of errors that could occur. You cannot obviously get all future issues, which is technical, but then that's where your blocking liability may come into play. But you have to try as much as possible based on how the software is supposed to function to identify the intricate liabilities of everybody. So you have the errors features on one angle. So who bears liability in terms of default from one party to do a particular thing. Then you have the claims on the other end, which is the claim property, which is from the end user perspective. I was debited twice, it was done this and so this. You also look at the logs, you trace it based on this to identify who bears this liability. So at the end of the day, you would achieve the same outcome. The outcome is to determine who would be responsible for such defaults. And it will be clearly itemized in your agreement. So this is just a structural way of doing it, and we've just put a back-end technical aspect to it through the log entries, through the tracing, through errors, and through claim properties to identify who would bear these liabilities. So for the other person who is asking, I'm a software developer and I build products halfway, what do I do if I'm not comfortable with? We have what we call the midstream termination clauses, and different issues could occur when you would have that would arise or lead to termination. And like we've spoken about before, if the software developer is assigning. An assignment here means a absolute conveyance of all rights, all intellectual property rights to a particular party. So if that's already clear cut in the contract, automatically it means that even if there's a midstream termination, depending on how you couch your agreement, yes, that unfinished product could be given to the recipient or the end user who has contracted the developer to build it. But you have to make it clear cut in your agreement. I guess that would answer that question. But going further, we would want to look at software license agreement and the variables, which is the some of the features that a lawyer would probably want to put into perspective. Also, a developer would also want to look at this because it concerns them. So in negotiating, so we've talked about software development agreement, which is different on its own. The software development agreement could consider things like developmental angle, the build up, and all those things, and who would have ownership rights and likes. And I think I need to make it clear that in a place where it's an enterprise solution and you are, say, a law firm, you don't need to own that particular product that has been developed by the software provider. You probably could just create a situation where, since you are paying him to develop it, he'll probably give you royalties or fees in the event that he licenses it to other people. So you need to make all this clear because it will just cause enormous pressure on your business when you begin to try to sell those products because that's not part of your business functions or features. So you want to, but these all are angles that come under the software development angle. Under the software license agreement, we have the software as a service, which is where everybody calls what they do right now, and I probably have different understanding of that perspective. And then we'll have the on-prem software. So the on-prem software usually is what people consider as software license agreement. On-prem here means on-premises software, which involves maybe a physical installation of that software. You have the software handy, like that widget scenario we talked about. This widget software solution is in your hand. You have it handy. But software as a service are softwares that probably you don't need physical access of it you don't require the physical access of you don't need to hold that that software, but you can access it maybe through an internet connectivity or other features. But then it's not a one size or a one case fit all. There are different scenarios. There are sometimes where you'll be required to even have the software installed while the software provider still performs some certain services. The argument here is that I cannot give you a software license if I'm providing a software as a service, in the sense that I'm not giving you the software to use or to hold. I'm only giving you access to use. So it's more like when I engage an artist to sketch for me. I've only engaged him to sketch. I don't own the artist. So that's the argument of the software as a service solution provider. The argument is we don't necessarily have to license. We probably just require that you pay a subscription, which some people call an SLA. We pay a subscription fee while we do a service level agreement and we help you with maintenance and stuff like that. Like I've noted, there are certain different dynamics. So it's not a one size fits all. So first thing you want to do is the granting rights in developing your clauses. So you want to look at the rights as a developer. You're looking at the rights you want to actually give the end user. Does he have the right to copy? Does he have the right to distribute? Does he have the right to sell? Does he have the right to reverse engineer or modify? You want to make this right as restrictive as possible to ensure that at the end of the day, you're not shooting yourself a leg. So you want to restrict this right as possible. You want to probably put some geographical limitations. You want to state that when the software is used outside certain places, it will be in breach of this agreement. And even in doing that, technically, you can even reduce your indemnity to state that any issues that occur outside the particular location, you will not be indemnified for such features. So these are technical ways of arranging or protecting yourself as a software developer. So you put some usage restriction as to the parties. Can the end user or the licensee allow his affiliate to have access to it? You're in the business of selling software, so you may want to restrict this as much as possible. Can this be transferred or can it be assigned? And we've talked about what assignability is, and we need to understand the differences here. The end user or the licensee who you've licensed the software to cannot assign the software and continue to use it. So assignability means a complete conveyance. So that means another third party will begin to use it. So you want to clarify and state whether you are limiting him from doing this. You also want to look at things like transferability, but transferability most times occur as maybe an operation of the law or maybe a merger and stuff like that. So if you want to limit the software to state that there will be no transfer of that software, it has to be clear cut. Because in the event that you don't state that clearly, the law court, because it's an operation of the law, we interpret it as a normal case and probably give you nominal damages. So these are considerations that you need to clarify in your agreement. We talked about specific functionality and technical architecture, and we use the widget monitoring system case study and stuff like that. So you want to be clear cut on this. But an issue that would arise here is what happens to when the software developer has given you the license to use the software, and then you want to build some add-on features, some custom-made features that are necessary. I would note that in agreement, what you would most likely see is that there's a clause that says that the software provider or the licensor will continue to provide updates for the software. Now, if I'm the end user, I'm going to negotiate a situation that states that every update would be compatible with the existing software that I use. But the challenge with that is that I may be hooking the software provider to continue to provide me updates. And don't forget that people are in the business of selling software, so they may not want to do that. So from the software developer angle, you may restrict the update to only 2 consecutive updates after purchase or after licensing this the software. So after any subsequent one, the end user may be required to make certain payments, but you can negotiate that to a reduced fee based on the relationship. So these are things you want to look at on the negotiation angle clearly. And you also want to look at the service level agreement, because every software has certain issues that would arise. So you want to look at the ability of software provider to maintain that software to ensure that it can perform a specific function. So issues when errors arise, and what are the response time, what is the level for, what is the remedy attributable to response time, who giving certain credits when they are continuing default and stuff like that, come under this specification. Warranties are clear cut. You need to identify the warranties. In fact, you may want to bring all the listings you've stated in the specific functionality of the software and input it in the warranties to show that in the event that the software does not provide particular function, this and this will be the liability of the software provider. So, well, again, I was talking about custom made, and when we're talking about custom made software, the question now would be who would have the ownership right to the newly added on features in a custom made. This is different from an update and upgrade. Who would have the ownership rights? I would say that you could define it in 2 ways. You could allow the software developer to have the ownership rights, knowing fully whether you're paying for it, but he's going to be giving you royalties. So when he sells that software to other third parties, he gives you royalties based on that feature, because it's going to be technical for you to start selling the custom-made features separate from the software. So that's a better way to protect both parties' interests, actually. Or you could agree that both parties would sell at the same time. So both parties would have the ownership right and they could afford to sell at the same time, but that's a little bit difficult. But yet the Corporate Act also gives them permission where 2 parties can own a right, and the cost of the parties will be required to distribute or sell. So it's very permissible. You want to look at termination. What happens in termination? How would the data be migrated? Who will be liable? Record keeping, and the whole stuff like that. And this termination angle would now take us to the source code and object code. All we're talking about software would seem more like the object code, which is the unreadable application of the software. But the source code is the programming language, the HTML, the JavaScript, and the likes. And the argument of the software as a service solution provider is that we are not selling our software to you. We are not licensing our software for use. We're just giving you access to use the software. So you don't need to have an arrangement for a source code escrow. And this is very funny because I recently had to engage or renegotiate a solution on this, and there was a lot of back and forth on this angle. So the question would be, if it's an on-premises software solution, which is a software license agreement, naturally, then there could be situations where there will be a source code escrow arrangement. Now, what's a source code escrow arrangement? It means that some incidents may occur that would necessitate the need for the end user to have access to the source code. So if, for instance, there are certain functionality that I need, and the software developer is unable to perform those functions anymore, maybe based on a severe denial of service or certain attacks, or maybe some internal mismanagement, or even in the event of insolvency. At that point, this incident may necessitate the release of the source code. Now, the source code will now allow the end user to modify the existing software so that he can continue to perform his business functions. That's the idea of the source code escrow. So the source code escrow is usually given to a third party who is holding that source code in trust of both parties. So until the situation or the incident necessitating the release of the source code occurs, the end user does not even know the source code. So in navigating or describing the procedures for of the responsibility of parties in the source code escrow, you need to make it clear cut. The end user or the lawyer who is representing the end user needs to make it clear cut or to show that that particular source code, the documentation, is sufficient enough as it is to build the software from scratch. So that means that the third-party source code escrow agent has to have some technical expertise to verify all the documentation that has been provided in the source code escrow. Now, when those documentations are upon verification is not enough or sufficient to build the software from scratch, then the obligation is now behoves on the software developer to provide this information. So the agreement again has to clearly define that when this occurs, the software developer would be liable for any extra cost. So naturally, most times, although it's still based on the amount of cost or consideration that is being granted, but the end user may be responsible for the major cost of creating a source code escrow. Because issues that arise would now be things as to updating, because every frequent update of the software could be stating some different programming features, and so you have to send that update to the source code escrow. So the source code escrow needs to verify it. So all these costs are continuing costs that you have to put in place. So most times, if you know, and then you look at the fact that the software, the end user may not even be in the business of providing the services that the software is providing. So what does he even need the source code for at the end of the day, when he may not even have the technical understanding to build the software from scratch? So in the agreement, you want to ensure that you probably put the name of the developer of the software provider, because obviously the issues that would have occurred would mean that the software developer may even be out of business. So you want to put the name of an employee of the software developer so that at the event you can probably pursue him and ask him to come on board to build the software for you. So these are certain things. But I know that Nana does not entirely agree with the source code escrow being introduced in a software solution service agreement. So I would want to hear his point of view on that angle before we move forward.
Okay, so this is a very interesting conversation because while from the legality of it, there's that point of view, I would think that it depends on the level in which the end user engages the software developer or maybe the software provider. Now, I'll use the analogy. So you rent a house, or we are aware of renting and leasing. So imagine renting a house and you rent a flat in the house and something happens whereby maybe it catches fire. Does that give you more like the right to get the full blueprint or to own part of or to own the house? Yes, you could take this to court and then you file for claims or pay something, but then does it give you the full ownership of that property, in this case, the software code? But I would think that more often than not, it depends on this. Is the client in this case, was he part of the solution requirements in that he was part of the team that actually got to bring about this, which means if he was, yes, by all means, the escrow is actually allowed for, the escrow agreement is allowed for. But
sorry to interrupt, Nana. From what you are saying, I would state that the rent analogy may not apply, because I like from what we've been talking about, you notice that there's no one size fits all, which I think you've probably considered and you've put a clause to, which is the end user involved in the solution. So there's no one size fits all. If in a rental agreement, most times, maybe say there's an insurance coverage that's put in place, and for that insurance, based on the consideration for the rent, the landlord may bear even the cost of insuring the property, or the tenant may bear the cost. And it's the insurance is to protect both parties' fund or source or money clearly. It doesn't mean that ownership of the property is given to the tenant. It just means that the tenant's money or expenses are protected, or his losses are protected, which is the same scenario for a source code escrow. Now, the concern for most software as a service solution provider is, oh, we don't want to give you our source code, because what happens when we have our source code, you become a direct competitor. But again, I would probably give us a little secret, because this by learning, so this is the benefit here. Now, in drafting the source code escrow, remember the source code escrow agreement is an addendum to the software license agreement, and it doesn't change every legal right that's been stated in the software license agreement. Ownership is clear cut. If the software licensor is not given ownership, it doesn't change by virtue of the source code escrow. What happens is you have to have defined in the source code escrow that every existing ability ownership responsibility still maintains. So at that point, the software licensee or the end user, in the event that an incident has occurred necessitating the release of the source code, would only be able to use the source code to modify or reverse engineer his existing product to continue performance. If he does not have the ownership right, or the right to sell, the right to distribute the software, he would not have that right upon release of the source code. The right will still be maintained based on the software license agreement. So I think that would cover the concerns of most software service solution provider, because then the rent analogy may not be exact. That's
So
my
in that case, that's where the just in layman term, the leasing analogy comes in place. So if you want something like that, you actually ask for a white labeled solution, whereby something specific to you is given. And if you ever want to do that, because if you are making those changes, remember that the client also has like thousands of users, that you are just one person trying to make sure that your business is protected. So asking for a white label solution allows you the flexibility to do all those. But then I must state, it comes at a premium, it comes at a cost. If you are paying $5 per month, like every other person, and you come with a new clause that you want to be able to modify it just to ensure maximum uptime or specific updates pertaining to you, then you wouldn't expect to actually be given that liberty. For example, there was one time we were meant to use one software, or I was using one software in the past, and it cost about $75 to actually pay per month for this. Now, when we asked for that specific feature that we wanted to make certain edits that fits the business process that we were running at that point in time, rather than $75 per month, they asked for $5,000. Now, if you see the difference in the premium, it means, yes, you have to pay the big bucks to actually get an instance of it so that you can actually do whatever you want to do or make any modifications. But then the ownership and the transferability then becomes another conversation altogether. So you have to create a different branch that allows you to do all this without endangering all 999 customers because of this one specific request. And mind you, because of operational flaws and even some certain things, it's going to bring in an additional overhead to the business. And the question comes, who then pays for this extra process or the extra source code as code proceedings?
Okay, so I think again, like you noted, it depends on which party's willingness to or the extent of consideration. That will determine how parties are willing to engage or enter a source code escrow. So I think we're pretty clear on that. Who would pay for it most times? It's not pretty clear cut, but it's a recurring cost or revolving cost that may be placed on the licensee, bearing the fact that the source code escrow is an integral and important asset of the developer. And even the other recurring cost of modifying and adding more updates to the escrow is an issue. So you need to, but we're short on time already, so would let that go. But we're open to any further questions from anybody. So if there's no, I would assume there are no further questions. I mean, parties are clear on.
Okay, so someone asked a question on the chat, and that's what is the usual way of resolving disputes? So I would deflect that to go.
The whole idea of what we've been talking about based on the abilities is to ensure that there's an amicable resolution of disputes. So obviously, when there's a log entry to show the errors or to trace the errors or the claims and who would bear those liabilities based on their inability to function at a particular period, it's easier to just amicably resolve this. It becomes clear cut. So, which is why I don't like when some lawyers want to maybe circle on this and try to bring out some new procedures or processes for disputations. Yeah, some the most amount of times these stuff are resolved amicably because the log entries are clear-cut evidence, basically. But yes, there are situations where it could escalate to court. So you have like an arbitration situation, and then you have um, a pure litigation situation. So you want to navigate your disposition clause to give parties perhaps the right to have access to arbitration, but also to be able to perform certain restrictions from using some injunctive, seeking some injunctive relief. So you want to open that clearly. Probably also want to identify the forums, you understand, so to between the parties. And most times usually challenge that. So I would usually advise that any party litigating the claim should have the right to institute it in his own forum and the likes. The case study or no, it's not possible within time, but like I was trying to do, I rather than restrict ourselves to the case study, who made it a wider in scope. So still the same system, still the same specific stating clear-cut specific functions and parties liabilities in a technical situation. I define it clearly in your standard contract, bearing in mind the legal implication or legal context of these liabilities that have been decided to be shared amongst the parties. But still the same concept, it's still the same contract. You just have to have an appreciation of the technical arrangement between the components or the actors, basically. Um, I think I think would do you think freelance software developers usually contact lawyers? No, not necessarily, but which is the whole idea of this webinar to enlighten us further, both from the legal perspective and both from developer perspective, which I think we've been able to achieve this. I would at this point, because we're short for time, if there's no other question from any other parties. Correct, that a software license agreement is different from software development. We've spoken about this basically, yeah, and we've spoken about that already, clearly stating that there's a difference between the software development agreement and the software license agreement. You could marry both in one agreement nonetheless, but there are distinctions and different things to consider. Thank you. At this point, I'll leave it to Mr. Tolu Ogundiji to close this webinar for us.
All right, thank you very much. It's been an insightful one. Ugochukwu and Nana and Paraventure, there are still, and then the host, Noya, thank you very much. And I'm very sure that there might be questions that you still have, people can still have. I'm very sure you can still pass across to FintechBloom. That's one of the specialization of FintechBloom to be able to attend to issues like these. And also Pronamic Hub looks into business development, capacity development, and leadership development. You know, the times are changing now. Technology, it's time you embrace technology and learn it at this point in time. So FintechBloom will always be your best shot that you can always send your emails to them. Send those questions. I'm very sure Ugochukwu and Nana will be able, and Noya will be able to respond accordingly, and then we'll always get back to you. So thank you very much for joining this webinar. We love you, and then we know that the recording shall be made available on YouTube so that you can go there, you can share. I'm very sure it will be using FintechBloom, so that you can go, you can share it, and then you share with every other person. Sit down with it, and then Ugo and Nana did a very good job. Should be able to compress everything within the short time. But trust me, you still have a whole lot to learn from it. So it's something that you want to follow. FintechBloom. You can send your inquiries to info@fintechbloom.com. It's on the chat. Thank you very much for joining. Thank you, everybody. Thank you, Ugo. Thank you, Nana. Thank you, Chinoye. And to all our participants, thank you very much. All right. So I wish everybody have a good afternoon.